Lawsuits in agriculture can arise for a number of reasons, and one element that might further complicate the situation is if it stems from a business transaction taking place in a different state. Well, Roger McEowen with the Washburn School of Law joins us now with some guidance on this. Roger, always a pleasure. Thank you for being here. So we're talking about a lawsuit filed based on a transaction in another state. And does that state's legal system then have jurisdiction over you? What's the outcome here?
Well, good to be with you, Suzanne. The answer is maybe. How's that for precision? It really depends on how involved you are in that other state. Back in 1994, the U.S. Supreme Court said that a party, particularly a corporation or a business, could be sued in a state where they're not incorporated if they had minimum contacts with that state.
Explain what minimum contacts theory is to farm businesses.
Well, over time, many courts have wrestled with the meaning of what minimum contacts is, but it basically comes down to whether the party is deriving the benefit of doing business with that particular state, or whether they're sufficiently availing themselves of the resources of that state. And that's oversimplifying the application of the court's reasoning, but I think you get the point with respect to that. And that applies to all types of businesses, including a farming business.
Can you give us an example? Have you heard or have you yourself handled a case like this?
Well, there have been a couple of recent cases on this. One that I can think of involves a farmer in Michigan who is just above the Indiana state line. And he ordered seed from an Indiana elevator, which was about 20 miles away from his farm. And it was the third time he had done that. Well, he bought the seed on credit, but then when it was ready for him to pick up, he didn't pay for the seed. And so the elevator ends up suing him in Indiana court, not in Michigan, but in Indiana. And he tried to dismiss the case on the basis, well, that the Indiana court didn't have jurisdiction over him. He claimed that he lacked sufficient minimum contacts with Indiana to be sued there. But the court disagreed, and they said, well, he had purposely availed himself of the privilege of conducting business in Indiana. It wasn't the first time he had done this. He could have reasonably anticipated, the court said, of being subject to the Indiana judicial system if he didn't pay his bill. And the court said, your due process rights haven't been violated. The elevator is only 20 miles away from your farm, so it was pretty convenient for you to do business with him. You should expect if something goes wrong, you're going to get sued in Indiana.
Yeah, that makes sense. Overall, what farmers need to keep in mind, and businesses?
Well, if you intentionally conduct business in a state and are sued as a result of your contacts and your actions with that state's courts will likely have personal jurisdiction over you. And Suzanne, I think this is more likely to happen to our farm businesses these days more so than in the past because of online transactions. You might buy machinery online, might buy livestock online. One of the things you need to ask yourself is the contract that governs my online purchase. What state law is governing that? And that's a key point to keep in mind, because you don't want to have to travel out of state, bundle your lawyers up, pay the fees to get them to this other jurisdiction that might be a long ways away. That's going to add up costs pretty quick.
Great information as always. Roger, thank you so much for joining us. That is Roger McEowen with the Washburn School of Law.